you're getting almost a personal presentation here. As you know, the more people, the more complicated it gets. This becomes easy. Now we can talk one-on-one with things. Yeah, you know, the unblossomed turds thing, I like that language, but this is more, and it's more Forrest Gump. It's that box of chocolates, except all the chocolate sucks. There's none, and how many of you have heard the term SB2? Okay, well, most of you have heard SB2. When bills come out, or bad stuff comes out of the California legislature, it always starts with two acronyms, AB, SB. If the bill originated in the Senate, it is SB, Senate bill. If the bill originated in the House, it is AB, Assembly Bill 2. And you'll find problems because they keep reusing the numbers. So if you go in and type in SB2, you'll see something to do with cops licensing from like 4 years ago. So you have to get to the right SB2. So you have to go to SB2 guns. That still might get you to the cops licensing because that dealt with guns too. But SB2 was a big deal and is a big deal. And if you are a CCW holder or want to be a CCW holder, then SB walking by with your CCW, whereas nobody else can unless they live close to it. You cannot take your CCW into the school grounds unless it is unloaded in the trunk. Unloaded in the trunk. The only way a gun can be on school property is unloaded in your trunk. You can't walk by, you can't drive by if you're a CCW. Other than that, I think that's Penal Code 626.9, whole bunch of regulations, but it's broken down to that. If you're a CCW, you cannot carry onto school property loaded. And you can't get out of your car with it has to be in the trunk, unloaded, right? Do anything with it on school property. That means if you go pick up your kid, your gun has to be in the trunk unloaded. Unless you make your kid run off school property and meet you on the street, then you can stay strapped and you're not violating it because you're within 1,000 feet of a school. You're allowed to be in the school zone with your gun, with a CCW. This is pretty easy, right? Like everybody should know this stuff. You know, it's like you're not going to violate anything. You're all lawyers now. You can figure out the nuances of SB2. Any commercial establishment open to the public without a sign. We've talked about that. That's the biggie. That's the one they wanted. That was the big one because it would ruin the ability of people to carry lawfully with a CCW. You literally couldn't go anywhere without putting your gun in the trunk. How do you challenge a disqualification? You get a DQ letter from San Diego Sheriff. First thing you got to do, and it's in the letter, they're not obscure about what you have to do. It tells you that you have to go through their internal appeal process, at which point you'll be denied again. And then you'll get your final denial letter. Within 30 days of your final denial letter, you have to go to court. The court has to grant you a hearing within 60 days. The burden is on the district attorney by the district attorney. And I'll fit that into the story I'm about to tell you. Burden's on the district attorney by preponderance of the evidence to prove that they were right. But all they're doing is referring back to SB2 and said they were denied because they had a TRO within 5 years. That's all they're proving. And they just have to prove you had a TRO within 5 years, point to the section in SB2, they win. And this is Client C's experience fighting the DQ in Superior Court. My client was charged in a road rage incident when two people lied about him pointing a gun at them. On the basis of that, he was charged with felonies that exposed him to 17 years in state prison. DA charged it. But at the same time he was arrested, law enforcement filed an emergency gun violence protective order. We'll talk about that when I finish. All that requires is a cop writing on a form that was mailed to a judge at 3 o'clock in the morning, and the judge signed it at 3 o'clock in the morning. Duty judge has to get up and read this one-page form. And what the cop is signing in the affidavit is, these people told me this. That's all he's certifying. These guys said this guy pointed a gun at him. And on the basis of that, a GV-EPO was issued, Gun Violence Emergency Protective Order, that required my client to, and by the way, this is how interested the cops were in his guns because they already snatched his carry. He had his carry on him when he was arrested, but he had a lot of other guns. And why this GVEPO, gun violence restraining order business, is being abused, the cops were so uninterested. They sent him home when he bailed out, and he had 24 hours to turn in his own guns. He was such a danger that he was given a gun violence emergency protective order and then allowed to go home, get his guns, and turn them into a FFL for storage. And by the way, you know what storage fees are. So he had to go to the FFL, turn his guns in, and then transfer them to his dad under interfamilial transfer, so his dad could get them back from the FFL because he was a prohibited person now with his gun violence emergency protective order. So he's got a criminal charge 17-year look, a gun violence emergency protective order, and 2 days after, sheriff from a detective sergeant from licensing shows up and snatches his CCW. Shows up at his house, says, give me your CCW. We got the CLETS that says that you've been charged in this case. I mean, that's reasonable in a sense that if somebody's charged with a gun felony, that they come and take your CCW. All right, so how did this play out? I convinced the DA these guys were lying before we even went to court. The DA dismissed the case before preliminary hearing. Criminal case dies. City attorney, who is responsible for the issue in defending the gun violence emergency protective order, I convinced them the same thing. We show up at the 21-day hearing and they dismiss the case and the judge terminates his gun violence emergency protective order with prejudice. I mean, ever since Apocalypse Now, that sounds pretty bad, terminating somebody with prejudice. So what's left? Said, well, go back to sheriff, get your CCW back. Remember, this all happened in November of 2023. So he goes back to the sheriff in March of 2024 and says, I want my CCW back. My criminal case is dismissed. My GVEPO is over. I said, sorry, SB2. SB2 says, and by the way, it came into effect 2 months after this happened to you. SB2 says if you've ever had an emergency protective order, a TRO issued against you, 5-year wait. So your TRO is dismissed in February, you got 5 years from February before you get your CCW back. And I thought that was bullshit. And so we went to court, we got the hearing. This was so confusing for the courts. This was the first one in San Diego County. I'm using the DOJ form that they made specifically for this. And the court goes, well, we can't take that form. And then finally, it forced them to take the form. They didn't even know where to send it. And then the DA gets it, and the DA has nothing to do with licensing. Nothing. They don't understand why they're in the middle of it. And I told them they're in the middle of it because the sheriff has better lobbyists than you in Sacramento. They don't want to be in the middle of it, so they put you in the middle of it. Now they don't have to come to court with the sheriff's lawyers to defend their licensing decisions. They made you go to court and defend their licensing decisions. So we had a hearing, and that hearing was about 2 weeks ago, week and a half ago. And the judge wrote a 14-page opinion saying and agreeing with me that taking a property right and a constitutional right from somebody on the absence of due process. Remember, we had no right to challenge the bullshit that was in that affidavit until we got to court. And when we got there, the case got dismissed. So the judge agreed with us and said that was a violation of due process clause of the United States Constitution and ordered the sheriff to return his CCW. First one in the state, I think, and got a 14-page written opinion, so I think it'll hold up. The problem was, they went back to the sheriff, and the sheriff said, all right, well, we got to send this to DOJ because in SB2 says once this happens, we got to go to DOJ before we return it. And what did DOJ say? Hey, this hasn't happened to us before. We got to send this up the chain. And what did I say to them? This is actually happening right now. If I don't have his CCW back by this Wednesday, I'm going to file an order to show cause why the sheriff shouldn't be in contempt of court for not following the court order. I'll ask for sanctions. I'm going to bill you, and I'm going to order the sheriff to come to court personally. I said, write that in the email to DOJ, send it to Rob Bonta. So I don't know where this is going, but this week I am going to be subpoenaing the sheriff if he doesn't have his CCW back by Wednesday. Might win, might not, but you know what? It will catch their attention. And that's the point. If we don't make this difficult, we're going to see more and more and more and more. We have to push back on this stuff. And unfortunately, this was a very expensive proposition. By the way, he didn't have USCCA insurance. And if he did, he would have been out of pocket nothing. Unfortunately, he was out of pocket high five figures to get all of this done.
What's the USCCA insurance going for now for the year?
Adam will answer the question.
Sweet, I need that.
If you're a CCW and you do not have insurance, you're crazy. You're putting yourself and your family in financial jeopardy. And I'm not talking about the criminal jeopardy. It's going to have to pay me and pay the investigators and pay the experts and pay for your bail. By the way, it pays your bail. It's the civil. You're covered up to $2 million. You know, and USCCA, from my experience, is the best product out there. There are other products you can choose from, but they're the one that I like, that I've worked with, has paid me no problems. They don't fight my fees. They pay quickly. I mean, this guy, another CCW, had his bail paid within a week. The money he put down for bail, he got a check back for that within a week. My fee was paid. He never even dealt with the fees after that. Let me finish up here. GVROs and TROs. What are gun violence restraining orders? Also known as red flag orders. And guess where you live? You live in the pinnacle of red flag orders in the United States. I think 50% of the red flag orders issued in the United States were issued in San Diego County. 50% of the California red flag orders were issued in San Diego County. 50%. Why? Mara Elliott, City Attorney of San Diego, made it a cause. And then they went to the adjoining police departments in the unincorporated communities covered by sheriff jurisdiction and private police departments, not San Diego Police, and taught them how to do it. And it's being increased and abused. Who can ask for it? What does it do? It stops you from owning or buying guns, ammo, magazines, or parts. And you got to turn in all your guns. Law enforcement can ask, as happened to my client, typically as part of an arrest. Who else can ask? Your immediate family, people you live with, employers, coworkers, teachers, roommates, someone you dated. Those people can ask. All the cops need as part of an arrest is that one page, literally a one-sentence affidavit got this guy's constitutional rights stripped from him. That was total bull. Just a lie, flat out lie. That's why the criminal case got dismissed. But he still lost his Second Amendment constitutional right. And we had to fight this over and over and over again at every level. So what's a gun violence emergency protective order? You have to be in court in 3 weeks. Courts in downtown San Diego, Department 61 is the only place. And the GVEPO is issued on reasonable cause. Is there a reasonable cause to believe you're a danger to yourself, mental health issues, or someone else? And that's all the cops need to do. It's a little bigger hurdle for someone not a cop, like if it's your neighbor that's doing it, or your ex-girlfriend. They have to actually go in and file an affidavit under penalty of perjury. But what it means is, if somebody's willing to lie, you're going to lose your rights, at least for a short period of time. It can't stop it. It's going to happen. And then the sheriff says you lost your CCW because that liar got a GVEPO or a domestic violence TRO against you. I have a companion case along with mine. I think they're getting their opinion this week. That was a TRO. It can last up to 5 years. You can be banned for 5 years with a gun violence emergency protective order. And it is a crime not to follow the order. You can be prosecuted for not following the GVEPO, not turning your guns in. So you say, okay, well, my guns are home in a safe. Go pound sand. I'm not taking them out. They'll get a search warrant and they'll break your safe. If those guns don't show up, they are on you. There is my number, my email, and I say this with all sincerity. I hope we never talk to each other.
Gary, I have a question about the training requirements. So you mentioned a couple of things that were mandatory for the training, such as an hour on mental health and storage. What else is in there that is mandatory that somebody has to have training in? In other words, let's say you have somebody with a disability who's unable to do certain things on the range. Is there a clause in there that'll prohibit them from getting a CCW if they don't do something?
No, the specificity of the training is pretty thin. with the absence of the mental health and the storage requirements. And so most of the trainers are doing just about anything they want to fill the time. They're explaining the law, they're explaining scenarios. I know that some of the trainers are using my cases. You know, that I've done lectures to the San Diego County gun owners on these cases, and with video. You know, I've got video of a CCW contact with somebody in a gas station and how that played out. And so they're using those things, and there's no specificity to it, but the sheriff requires the shooting. You know, certain shooting, I think up to 7 yards is the limit for San Diego County Sheriff, is the most you have to shoot at. But the shooting's the smallest part of it. I mean, you're usually done with the shooting in, 30 minutes, and that's if you're slow. I mean, I did my requal. I was done with the shooting in literally a minute and a half. We were finished because I changed mags quick. You know, change, change, okay, we're all done. You know, it's just, if you're good with your gun, you're going to do it fast. It's the people that are uncertain with their guns take a little longer, but it's not more than 30. So if it's 30 minutes, that means you got 15 and a half hours to fill. I don't know what they're filling it with. I mean, I think I'm going to ask somebody for their syllabus just to see, what are you guys doing? What are you talking about if it's not shooting for 15 and a half hours? Okay.
So one of the things on that, with USCCA also being a training organization, we have so many partnerships with instructors and ranges and things like that. The 16 hours and 8 hours and all that, actually filling that is pretty easy, because we have all kind of curriculum on all kind of topics. Like Gary said, a lot of scenarios now, because we have all these real cases. You know, a lot of these places, these are students that have been taught by ranges and instructors that are in these incidents, so we can speak on that. So that filling up the curriculum, especially when they're partnered with USCCA, is actually pretty easy.
It's forced training, which I sort of agree with if they hadn't been such jerks about jamming things down people's throats, and they're doing the same with training. I think that what's happening is they're forcing training on people that they really should have got after their shooting class. Anything else? Thank you for your time.